Welcome and thank you for joining me today. I'm going to be discussing Emerson Bar Review Hour 1, Day 1, if you want to preview that video before going on. But I've already done other videos sort of succinctly covering what's in there. However, right now, what I'm doing is I'm going to be going over some things I've read in uh, black letter outlines on Contracts 5th edition in Chapter 4. And I've taken some quick notes on what I wrote, what I pulled out of there. Now, what I was looking up was the Williston and the Corbin rules that Emerson just briefly said a couple of sentences on. Because for some reason, it didn't really hit me entirely until watching this video like a second time. And I went back to my different books, my horn books and whatnot, and I was really having trouble finding these two characters and recalling their significance. So basically, I also found a couple of articles on Google Scholar, and then I ascertained exactly what it meant. Now, there's a lot of things that were very familiar when I was reviewing it. The Four Corners Rule, Parol Evidence Rule, the Collateral Contract Rule. Of course, there's two versions of that. Then the Williston's Rule, which is kind of like basically following, it by the book. Express writing is the final expression. And he actually broke apart into details, expounding on it. And occasionally there's, some wiggle room to allow evidence if there's, some like a partial integration, or most of the time the appearance of the writing's gonna be a complete integration, and you'd follow the reasonable person standard. So now with Corbin is in line with Restatement Second, and there's of course the UCC approach, which is seen in 220B and A, and also instead of them coming right out and saying, it the way that it's just discussed by these professors and scholars on the law, it is said in a more uniform way, with goods, of course. And basically, what they do is they sort of use related terms like what was the ordinary course of dealing, what was the trade usage, what was happening in the course of performance. So we get a lot of different areas discussed here, so I'm just kind of going over what I wrote down and jotted down in notes. And so they broke it apart based on parole evidence and also interpretation. So one of the things that they were talking about was interpretation and outlining it, and then they showed the plain meaning rule, Williston's rule, and then Corbin's rule. So basically, Williston's saying in most cases evidence of subjective intent of the parties and the meaning of the language that's in the contract is not allowed. Under Corbin's rules and Restatements Second, which is a more modern approach, all relevant extrinsic evidence is admitted, okay? So parole evidence is for the content of the contract, not for the interpretation of the intent. And so these areas are covered. By the way, I have a whole playlist in here if you're new to the channel that is EBR. It's titled EBRE. So what it is alongside the Emerson Bar Review are some other areas that I pull out and I expand on, or sometimes I'll narrow it down and make it shorter and briefer, depending. Because he gives a lot of ample examples of the subject matter. He also talks about different past released bar exam questions and answers. Sometimes I read them off that are in line with what he's trying to show. So I'm going to add this video to this playlist, so it should be 1.7 instead of 1.6. And so basically he's saying in the video that most of the questions are going to come up regarding formation, do you have a contract? But other times, it's going to be to clarify the terms, Parol Evidence Rule, ambiguity, mistake. That's the other, little gap area that you want to fill and concentrate on. So he talked about these two theories, and I was like, what? Now, I knew all the terms in there, but I just sort of more or less memorized Parol Evidence Rule. And, I actually got a lot of books, and I was like, well, wait, if it says this here, and I was scratching my head. I've got a Arthur Best on contract. I've got a whole bunch of books, and I'm like reading them, and it seems like, when you read scriptures or something, it's like this part contradicts this part, and this part doesn't agree with that part, and when do you apply this? So it can get kind of dicey. But I snipped this from one of the two articles, and I'm giving you the link to both of the articles. One of them's really long, but they're older, and this one says, to paraphrase Professor Corbin, interpretation is the process of determining the meaning of the words and the symbols used in the contract, while construction is the process of determining the legal effect of those words in light of many factors external to the contract itself. So he's written a book, Arthur L. Corbin on Contracts, and here's another snippet I just pulled out to clarify this vast cloud of legal rhetoric. A few rules should be set forth. And then they go on, they have a lot of footnotes in this particular article. I will show you the link in a minute. So they made a checklist that was adapted from Corbin, and I'll kind of have you go through that, because really I think the predominant in many of the courts in many of the states in the United States, they use more of a Corbin or the restatement second than they do. There's actually a restatement third, but so here's what they broke it down with. It says, few subjects connected with the interpretation of contracts present so simple and uniform a statement of principle, bedeviled by such a perplexing and harassing number of difficulties in its application, as the Parol Evidence Rule, or Parol. Now, a lot of people pronounce it parole, like being on parole with an E at the end, and a lot of people misspell it. But for the purposes of law, it should be spelled without an E at the end in the United States, and it should be pronounced parole. But a lot of times, it's just people use phonetics, just to clarify that. And sometimes I slip back and forth between the two myself. You say potato, I say potato. Let's call the whole thing off. Is that how it goes? Anyway, so while the Parol Evidence Rule may be easy to recite. It's much more difficult to pin down in practice, as discussed previously, as it is apparent from the foregoing statements of the Parol Evidence Rule. Before a trial court reaches the question of whether the evidence offered regarding a prior agreement or prior discussions will be admitted before the trier of fact, the court must make the following threshold determinations. Now, they broke it apart. 1, 2, 3, 4, 5, and then it's 6, 7, so they had 7 points, and then they go into detail. I could read these off for you, but I invite you to go get the article and read it yourself in the interest of time. So basically what you have is a more narrow approach with Williston, a more traditional, if you want to put it in Democrat and Republican, you might say Williston's the Republican and Corbin is the Democrat. Corbin is liberal, and the Williston is more of a strict, narrow, rigid, traditional approach. Don't mess with it. Just, we haven't got time for that. So you've got a different approach to the rules. Now, this is one of the areas that the books that I went from, and I'm going to cut and paste this all below as to make it easy for you if you want to look further. But I got these articles off of YouTube. By the way, I'm putting the playlists also below, so you can go directly to the playlist for Emerson on contracts. There's 13 videos in there, and you could see the first one on the top, and then so this is basically what are the difference between these two. And one of the things I'm telling you that I think is very important is, a lot of times people will they'll memorize. There's just too much stuff to memorize, But when you're writing an essay and you can put in there details that are true about, hey, most courts interpret it modernly this way, but there are those dissenters or those traditionalists, if you will, that stick with the plain meaning rule. So again, you have ABC of the main things with parole evidence. Now, there are other expanding, let's just put it this way. Corbin and Williston did not just comment on this particular subject, parole evidence. They talked about a lot of other things about contracts besides that. It's kind of like the Falscraft case in tort law. You've got two main judges' opinions. You've got the majority opinion, you get the minority opinion. Right now, it's my understanding in most jurisdictions that the majority opinion or the modern opinion would be Corbin, but there's going to be areas where they strictly interpret things and they don't want to hear it, they don't want to hear about these nuanced things that happened. They just want to get straight to the point. They're like, well, it's not in there. So that's the long and short of it. All right, well, thank you for listening. I'll do another video next time I can. I'm actually studying a couple of other things too, and I appreciate each and every one of you. If you have any comments, if you'd like to add anything, please do. If you have suggestions for anybody, that's great too. Love to hear from you, and thanks again. Take care. Bye.